And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it.
Go ahead and hit that like button, y'all. Today we have an extraordinary moment in the YSL trial. This is akin to the Glanville Kirk out on DA Love. At this point, we have the Whitaker Kirk. Whitaker absolutely went ballistic on DA Love. And you're going to see what became of this situation. What happened after Whitaker literally just laid all the way in to DA Love today. We haven't seen anything like this from Whitaker, I assure you. Also, we have another clip. Shout out to Empress Fox on X, y'all. Shout out to Empress Fox. She always coming up with something interesting. If you wait to the end of this video, we're going to flash back to earlier in the day where DA Sprinkle is on the stand. We have a super zoomed in Sprinkle and a super zoomed in Love side by side. Some people say that Sprinkle and Love were sending messages back and forth. Love at her computer and Sprinkle using the computer on the witness stand. I don't know what they were doing. But at the end of this video, you can see a little preview here. At the end of this video, we have that whole moment so you can be the judge. Other than that, y'all, again, we always appreciate you. Hit the like button, y'all. It costs nothing. And it helps us out so much. So I appreciate that. Subscribe, comment, and let's get into it.
In fairness, when we went through this, there's the main focus was the speculation about what Donovan Thomas's sister knew and her reactions, and then just kind of gossiping on that. He's Thug's road manager is in the transcript, line 85, page 85, line 22. It's just not it has it as unintelligible. So, in fairness, that particular part wasn't kept out, I don't think, for the same reasons as everything else in this passage. However, I will say, going off my recollection, I don't believe that I believe that came up during the examination of Mr. Zachary, and I don't believe Mr. Zachary denied that. I thought he said he used to be Jeffrey's or Thug's road manager. So that's already come out.
Is that the only sentence that you wanted in?
Out of this group, yes, I'm given that the way that the court has ruled on the rest of them, I'm not even going to take time up arguing about any sentence other than that one in this group.
Okay. And didn't he admit that anyway?
Not to my recollection, he did not.
Did you ask him about it?
I think unless it was necessary that I continue doing what the court asked me to shorten, which was confront him with every single line in his interview, that his saying he didn't know, he lied, he's high every time the state asked him a question, and the court found at the time he was testifying that we had gotten out enough to play the entire interview. I believe that situation hasn't changed. So I believe that this is information that contradicts and is a prior inconsistent statement to his trial testimony.
Well, he, much like Mr. Copeland said, some of it was true and some of it wasn't.
Your Honor, when I was going through, there were repeated objections. The court admonished the state to not belabor confronting him with every single piece of information. The court reminded the state that he didn't remember anything when it came to us. His memory returned with the defense.
Okay. I mean, that wasn't out to begin with. So the next one, 19.
Yes. So on cross-examination, we had originally said, okay, this is out. On cross-examination, and since this hearing, defense has continually asserted and made efforts to show that Kenneth Copeland was the person that, in fact, did this murder, I believe. They even went so far as to ask Mr. Zachary about his belief as it relates to Kenneth Copeland in committing the murder. We think that given the doors that have been opened since this hearing and through Mr. Zachary's testimony, that Mr. Zachary's statements and what police believed and how and why police believe what they did are relevant and pertinent in this trial, that the pertinent information that the jury should be entitled to hear.
This line, my understanding and belief is that Investigator Dennis is the one saying this. That's and talking about how the streets had already convicted Woody and the rest. I have no idea what Investigator Dennis said during an interrogation when he's asserting facts or alleged facts would be admissible. His out-of-court statement.
It's not coming in. The fact that he might be saying that in an interview does not mean it's anything that was the actual official position of the investigation. The one that you number 20.
So, Your Honor, as it relates to Antrevia Smith and who shot up her house.
Yeah, it was hearsay before.
We're not asserting that Quindarius Zachary says they say Kel and them is. We're not asserting that Kel and them shot up the house. We actually believe that Kelvin Watts was in the house. So, in as much as hearsay is statements out of court that are asserted for the truth of the matter being asserted, we're not offering it for the truth of what Quindarius Zachary says. He's trying, we believe, to take attention away from YSL by saying Kel, the rival gang, shot at Antrevia's house. We have evidence that Quindarius Zachary and Antonio Sledge made a video threatening Kelvin Watts after, and that Antrevia Smith gave that video to the police after her house was shot up. We have evidence that her back door was open, so there is circumstantial evidence from which the jury could infer that they were in fact there at the house. Given that we're not offering it for the truth of the matter asserted, and given the testimony that has come out, and given that Quindarius Zachary trying to protect members of YSL for something that the jury could reasonably infer that they actually did, we'd ask that the court allow us to put up that information in the interview.
All right, that's still out. I'm not changing my mind on that. So 21, it was, did you establish that Mr. Zachary was present?
Actually, Judge, what I think that we did not argue and the court did not have, was not made privy to, is the fact that Mr. Zachary said that that Mr. Zachary said that they came back and said, we just shot up Lucci's mama's house. My understanding is that the court said that we needed to prove that Shannon was present when they said that, and that under those circumstances, it's admissible as an adoptive admission. But given that Mr. Zachary also said that Kenneth Copeland said to the other two people that he told police committed this shooting, let's ride, that the three of them came back and that they said, we just shot at Lucci's mama. All of this is co-conspirator hearsay that should be admissible against everyone in court. Mm-hmm. And Your Honor, if the court is really not going to grant reconsideration, but will summarily deny,
I'm not summarily denying anything, or we'd be done and we'd have the jury in here. I'm listening to what you have to say about everything.
This is a co-conspirator statement. that proves elements in this of the offenses charged in this indictment, we'd ask that the court reconsider and allow the state to put in evidence that.
All right. So what did you establish that Mr. Stillwell was present when Copeland said, we did it?
I believe that circumstantially, the jury can infer based on what he actually says in the interview.
Okay. So no, then that won't be changed either.
And Your Honor, it's.
Yes, ma'am.
You
can argue circumstantially anything, but this statement, this part of the statement's not going to come in. Number 25, what's different now that should be reconsidered?
There was, I think, a specific cross-examination question about Mr. Zachary's opinion regarding who did this and why. And I think, again, given what information has come out before the jury, Mr. Zachary has shown himself willing and wanting to protect the people he gave previous statements about. And I believe that this information is inconsistent with what he testified to at trial and should be allowed as a prior inconsistent statement.
Okay. But in terms of establishing a foundation that he had a basis to know that anybody did this because they wanted a name, that didn't get established, right?
Your Honor, so is the court unwilling to consider what was said in the actual interview as
I already
establishing?
considered what was in the actual interview as establishing or not establishing, and I made my ruling. So if nothing in the testimony developed that foundation, then the ruling stays the same. So that would take care of number 29. And then, 28, 25 and 29, which takes us to 30. I don't recall hearing anything that, can you offer anything that should change the ruling on that?
Considering he denied everything he told them previously, I don't believe I can.
And then what's 32?
Judge, I'm not asking for any more reconsideration. Thank you.
All right. Okay, let's get Mr. Sprinkle back and the jury out.
And Your Honor, also before the court does, I just want to make the court aware that we did make efforts to get this video extracted and not pixelated, and it's going to be pixelated unless it's played through evidence reviewer. So we will be having to play it through evidence reviewer. We were not able to get a way to play an evidence reviewer video cleanly and plainly without evidence reviewer itself.
Oh, Your Honor.
Yes. Oh, yes, thank you. Ladies and gentlemen, so before we broke for lunch, there was some discussion with this witness about comparing Defendant Stillwell Exhibit 44, which was a picture with a State's Exhibit 510, which was essentially the same picture, and there was a little box. And I just wanted to let y'all know that there was nothing in that box at the time it was introduced into evidence, because at that time it hadn't been established what the box meant or what was in the box could come in or anything like that. So that's the reason that there was nothing in that box. There's not anything nefarious about that. Okay. All right. Just want to let y'all know that. Okay. Go ahead, Mr. Sharp. Thanks for the reminder.
Your Honor, permission to publish DS-44?
Yes, you may.
Actually, you know what? 510Y. State's Exhibit 510Y and Defense Exhibit DS-44.
Okay.
Okay, we can agree that that is the same picture?
Yes, the photograph is the same. The stuff around the photograph, the frame and whatnot is different.
Okay, and that photo is also on the screen, correct?
Yes, the DS-44 is on the screen. That's correct.
Okay. Now, I want to get this right as far as what your testimony is. You've been to the exterior of the Sky House, correct?
Yeah, I've been outside the Sky House.
As part of this investigation or another investigation?
It was this investigation.
Okay. You've never been inside the Sky House or inside the units?
No, I've never been inside one of the units.
Okay. Is your testimony that this is a picture of Shannon Stillwell in the Sky House or not?
I believe that it is, though I've not been inside the Sky House. That was my recollection from everything I put together, that was him standing inside the condo at the Sky House that evening. But if you were to ask me, like, if I stood where he is standing in this picture, no. So I can't say with 100% certainty now.
Okay. Now, in States 510 Yankee, I believe it is, there's a date and time on that photo, correct? On that exhibit?
Yes.
Okay. What is the date and time?
January 10th, 2015 at 9:58 p.m.
2015 at 9:58 p.m. Okay. Now, that is the date where someone posted this photo with this caption on social media, correct?
That's correct.
That is not necessarily the time when this photo was taken.
That's correct.
In fact, do you know who took this photo?
Well, there was somebody who told me they took the photo. I showed them this photo and they told me they took it.
Okay.
It's written in my report, so if I'm wrong, please let me know, but I'm pretty sure I recall who told me that.
Okay. And were you able to determine when this photo was taken?
I can tell you, all I know is what the person told me.
Okay. You're not, and I don't want to elicit hearsay, but you're not, please keep that up, Mr. Kokomo. You're not telling the jury that this photo was taken on January 10th, 2015, are you?
I don't know when the photo was taken.
Okay. Well, you're familiar with the seasons here in Atlanta?
I am.
All right. Sunsets?
Yes, that's correct.
Okay, 9:58 p.m. on a January evening. You would agree that that photo does not depict what the Atlanta streets would look like at 9:58 p.m. on January 10th of 2015, does it?
No, it'd be dark out.
It would be dark out if that was in fact the time.
That's correct. Eastern Standard Time, it would be dark out.
Okay, so bottom line is, this is Shannon, but we do not know, we don't have any information to say when this photo was taken.
That's correct.
Okay.
Well, I was told when it was taken, thereabouts.
That information, I understand that we're getting back in this hearsay. That information wasn't that it was taken that day, was it?
That's correct.
It was taken another day.
That's correct.
So this photo does not place Shannon Stillwell at the Sky House on January 10, 2015, does it?
Maybe it does, maybe it doesn't. I don't know. I don't know. Like I said, I don't know when the picture was taken.
Your information is it wasn't taken on January 10th.
That's right. Well, it was posted on January 10th, but I don't, like I said, I know that's not, I don't know that it was taken on January 10th. If the person who told me something else said otherwise, then it wasn't, or was telling me the truth, then it wasn't.
Okay. Let's talk about, and you can take that down, Mr. Kokomo. You can take that. Thank you. You became involved in this case in January 2016, correct?
Around that time. It may have been a little bit before that, but that was when I really started getting involved.
And I've read your report. You reviewed certain work done by other individuals, correct?
I did.
Okay. Now, my question to you is, were you provided with Detective Thorpe's file?
I was.
His entire file?
Well, I have what he gave me. Was that everything in his file? I don't know. I'm sure I asked him for everything in his file. I hope that he gave me everything that he had.
Do you have his rough notes?
I don't know that I got. No, I don't think I did. If it's not so with me, everything that I receive would be digitized. So if it's not like, in other words, if I were to get something like rough notes, which if he were to just give them to me, which would be unusual, and I would remember something like that, I would have immediately scanned them anyway, and they'd be reduced to digital form. If they're not in the digital case file, then I don't have them.
How about Investigator Dennis and Investigator Gaither? Did they give you case files?
They gave me. I wouldn't go so far as to say well, I guess it depends on what you define as a case file. They gave me cell phone records that I asked for, various videos and cell phone data extractions. I remember meeting with Dennis in particular, at least, it would have been multiple times, but yeah, and just sitting at his computer and him just saving things like cell phone records and whatnot to like an external thumb drive. So when you ask me if they gave me case files, it'd be something like that. It would be like data that was pertinent, like cell phone records, that kind of thing. But as far as like a completed case file, I don't know if I received anything quite like that from them.
Did they give you police reports that they authored?
Yeah, I seem to remember they did.
Did they ever indicate to you that some of their police reports were missing, that the Atlanta Police Department had lost them?
No, I don't recall. I don't recall anything specifically about any police reports being deleted. They don't type them on a typewriter. There should be a database. I've never heard of that. I don't know how they would just be deleted. There'd be an audit trail or something. So no, I don't recall anything like that. It's not to say that nothing about like that was said. I just don't remember it.
Right. There would be a trail, an audit trail for reports that are typed in, but then go missing, correct?
Well, yeah, you would think, right? Like I said, they don't type them on a typewriter. It's some sort of database. I mean, I guess maybe I'm speculating a bit, but it's just common sense.
Judge, I would object speculation if this witness can't say.
Let's talk about these videos. When you received the case file, we had a surveillance video outside the barbershop from various angles.
There were 2 angles, I believe, that were pertinent anyway.
I think it was 3, but I got you.
Okay.
And then video outside the Texaco.
Yes.
Okay. I'm going to ask the same question since you volunteered that Mr. Copeland is not on the Texaco video.
Mm-hmm.
Do you see Mr. Shannon Stillwell on the video?
No.
Outside the Texaco?
You do not.
Okay. Now, as part of an investigation, leave you out of it. Part of an investigation is to obtain surveillance video, correct?
Yes.
And now when you take over, you said January 2016. I'm saying take over. Maybe that's not the correct word. You became involved January 2016, correct?
That's correct.
All right. That's a year after this incident.
That's correct.
Okay. Is it fair to say that over a year's time, things can happen with surveillance video, the availability of surveillance video that would make it difficult for someone taking over a year later to uncover surveillance videos that had not been retrieved yet?
Oh, yeah, absolutely. Surveillance videos they're just stored on computers, and eventually, but they don't have infinite storage. So there's a retention period that's oftentimes very short. It can be 48 hours to 2 weeks, but a year, I wouldn't think that you'd be able to get surveillance video after a year from anywhere, unless the people that maintain the video just like preserved it on their own without the prompting of the government.
And in a situation like that, the expectation of obtaining pertinent surveillance video would be on the original investigators, not someone taking over a year later like yourself.
Yeah, I mean, maybe particularly back then. I mean, maybe now with all these private companies like Ring, maybe they retain their video a little bit longer, but like a gas station where they just have the storage mounted inside their facility on like a hard drive, Yeah, you're not getting video after a year unless, like I said, they took the initiative on their own to preserve it.
And these time limits they're known to law enforcement. You know about these time limits, right?
Oh yeah,
Okay, it's not a secret.
no,
Okay, and that's why it's important to obtain surveillance video quickly in an investigation. It's
yes,
going to be pertinent. Okay, so Green Store. You know that is Mommy's Grocery on Glen Street, correct?
that sounds right. I'm familiar with the Green Store. I can't recall the specific address, but that sounds right to me.
A minute from the barbershop.
Okay, I don't know if it's
All right.
I don't know if it's quite that close.
Okay. Question that I have, when you took over this case and reviewed the statements, you became aware that Kenneth Copeland placed himself at the Green Store, according to his rendition of events, at the approximate time of the shooting. Correct?
Objection, Your Honor. Misstatement and of the
Can
facts.
you rephrase?
Kenneth Copeland placed himself, upon your review of the work that had already been done on this case, you became aware that Kenneth Copeland, in his statements to police, placed himself at the Green Store at the approximate time of the shooting.
Wait, placed himself at the Green Store again. I don't know because the thing he wouldn't have during his statement he didn't know the exact time the shooting occurred. So I don't know that he would be able to say that I was there when the shooting occurred.
I know, but you have reviewed surveillance. You've reviewed the times. And what I'm asking is, did Kenneth Copeland place himself at the Green Store, to your knowledge, at the approximate time of the shooting?
So if the 911 call was at 7:22 p.m., which I believe it was, from what I recall, Mr. Copeland's cell phone tower logs placed him in the area of the Green Store starting at about 7:26 p.m.
Okay. So within 4 minutes of the shooting, he's claiming he's at the Green Store.
I don't know if he claimed that. That's just what I found in his cell phone records. I don't know if he was actually at the Green Store at that time.
Did you not listen to his statements that he gave?
I did.
His June 10th statement. Okay. Let me just ask you this.
But I just don't know if it was that specific where he said, at this time I was at the Green Store. This is based on my review of his cell phone records, trying to piece together his timeline outside of the interview.
Okay. In your review of the case file provided by Detective Thorpe, did you ever see any surveillance from the Green Store?
No.
Did you ever make any efforts to obtain surveillance from the Green Store?
No.
Okay. McDonald's on Cleveland Avenue. We'll ask the same question. In the case file provided by Investigator Thorpe, did that have surveillance from McDonald's on Cleveland Avenue?
It did not.
Okay. Did his documentation ever document a reason why that wasn't included?
I don't recall. I believe I just don't know. I don't know why it wasn't included.
As part of your investigation, albeit after a year,
Mm-hmm.
did you ever obtain any video from McDonald's?
I didn't.
One last thing. Do you have your report in front of you?
I do.
Okay. As part of your investigation, I think you testified. Well, let me ask you this. Your role with the DA's office, it seems since 2013, has kind of been a dual lawyer/investigator role, correct?
Yes.
Okay. You're not in standard courtrooms necessarily litigating cases. You're doing more investigations.
I do the preliminary hearings on the murders, but yeah, for the most part, I'm just investigating cases.
Okay. Now, as part of your role in this special role within the DA's office, have you obtained training about forensics and evidence collection and things of that nature?
That's a broad question. I've been to there. Yes, I have attended training and CLEs and that kind of thing. It may be a little bit more specifically.
Okay. You're familiar with gunshot residue.
Yes.
Okay. And one of the places gunshot residue can be looked for is someone's hands, correct?
Yes.
Okay. And hypothetically, if I were to hand or fire a firearm,
Objection, Your Honor. This is improper for this witness.
I think that's a foundational objection.
I'm going to ask him about the work he did in a second.
A hypothetical.
I'm just getting there. Okay, well, forget about the hypothetical. Can you test someone's hands for gunshot residue?
Yes.
Okay. And the time window for testing someone's hands for gunshot residue is
Objection,
very
Your Honor.
limited, correct?
I don't. Foundational.
Objection, yes, there is a foundation objection. Thank you.
Sustained.
Do you, as part of your job, do you seek out search warrants to obtain evidence in criminal cases?
Yes. Well, I draft them and review them with the DA's office investigators primarily, and then they seek them out as the affiants.
So much like a homicide detective, you're able to look at a scenario, decide what sort of testing you would like on a certain piece of evidence, and then have the investigators that work with you draft such applications for a search warrant.
Yes.
Okay. And certainly, as in this role where you're seeking evidence, you know about the rules of evidence collection and what can be collected and the timelines that it can be collected in?
Yes.
Okay. Your Honor, I'd move to, I submit that ADA Sprinkle is an expert in gunshot residue collection.
No, I don't think that's been established.
Okay. Did you seek gunshot residue testing in this case?
I certainly contemplated it on one specific item, but that ultimately didn't work.
Well, you in fact drafted a search warrant.
I did, yeah.
Okay. So let's go back. Hands, there's a limited amount of time that you can search for gunshot.
Objection,
residue.
foundation.
You need to establish that he, if you can, whether he knows that.
Do you know about the timeframes general as they apply to the collection of gunshot residue off of different types of objects?
No, I don't know that it's static. I don't know if it's, the particulate matter that is expelled from a gunshot just dissolves after a certain amount of time. I don't think that's how it works.
Right. It remains. That's
And
my understanding is it remains.
unless there's some external force that removes it.
Like sweat or washing your hands or something like that.
Objection,
correct?
Your Honor. Foundation.
Sustained.
Okay. The rules for those time frames are different from hands to other objects. correct?
Objection, foundation.
Sustained.
On May 9th, 2016, well, you were following up on with Hertz Rental Car about the Infinity, correct?
It would have been around that period. I don't remember if that was the specific day, but that sounds about right.
Okay, and through investigation, you were able to determine the actual VIN number of the Infinity, correct?
Yeah, I believe it was just within the records that is Hertz sent us.
Okay. And on May 9th, 2016, you located that actual car, the Infinity, correct?
Not me personally, but investigator. Well, maybe I figured out where it was. Somehow or another, we figured out it belonged to a private citizen in Mississippi.
Miss Cleveland, who lives in Como, Mississippi, correct?
Irma Cleveland, yes.
All right. And you confirmed that the car, the physical car, was in fact in her driveway on her property, correct?
There's some law enforcement officer drove out there and photographed it.
Okay. And on May 31st, 2016, you would agree that is 1 year, 5 months after the Donovan Thomas shooting? Approximately 1 year, 4 months?
Yes, that's about right.
Okay. After finding this Infinity in Mississippi, you drafted a warrant, a search warrant for a search of the Infinity, correct?
That's correct.
And in fact, in that search warrant that you had drafted, you were looking for two things in particular, correct?
I remember gunshot residue was one of them, I believe, and also some data from the computer system.
Right. You were interested in extracting the contents from the computer system of the vehicle, the Infinity.
Mm-hmm. That's correct.
And you were also interested in a search for gunshot residue from the inside of that Infinity, correct?
That's correct.
Okay. Did you specify what parts of the car that you were seeking to have searched for gunshot residue to have wiped?
Well, I don't have the draft in front of me, but I would imagine the headliner, the cloth that kind of that is affixed to the ceiling of the vehicle.
Why would you have chosen the headliner?
Just in my experience, that's traditionally what's analyzed for gunshot residue inside a vehicle.
It's made of cloth?
It is. Well, I usually, I guess now that you mention it, I don't know for a fact that the headliner in this particular vehicle was made of cloth.
Okay. And it also would be at the top of the vehicle where the particles are likely to shoot up when the gun is expelled, correct?
That's correct. Mm-hmm.
Okay.
Objection, Your Honor. Foundation relevance. 403.
Sustained as to foundation.
Well, as a drafter of the search warrant, you felt the place to look for gunshot residue was the headliner of the vehicle.
Yeah, I don't remember if that.
Asked and answered, and with respect to foundation.
Because he didn't answer the last one because there was an
No.
objection.
And
You didn't
foundation.
answer that.
You thought the headliner was a good place to look.
Yeah, I don't know if I just in the search warrant I said only take out the headliner. It was probably broad enough to allow the law enforcement agents to be executing the search warrant broad latitude in the surfaces that they analyzed.
And you were interested in having this search for gunshot residue inside this vehicle done, even though 16 months had passed since January 10, 2015, correct?
That's correct.
All right. No further questions. Thank you.
All right. Are there any other defense counsel? Mr. Weinstein.
Good afternoon, DDA Sprinkle. How are you?
Very well. How are you?
I believe we met once before, but my name is Doug Weinstein. I represent Diamante Kendrick.
Okay.
It's good to see you again.
Good to see you too.
So you've had some testimony today about people's general location with respect to cell tower, cell tower data that you collected, correct?
That's correct. That's correct.
And for a cell tower, you generally have, for example, in some towers, you know the tower and it might have 3 antennas, each of which, for example, have a 120-degree arc, correct?
Yeah, that's the general rule. Yeah.
And so when you're locating people, when you testify to that, you're testifying about their general location because of the antenna that it's hitting, correct?
That's correct.
But you don't know the actual location of that cell phone, or even if it's within that 120-degree arc, do you?
No, you don't know. Well, there's a good chance it's within that 120-degree arc, but the exact location within that arc, no.
When you say a good chance within that 120-degree arc, I mean, you went to Georgia Tech, right?
Yeah.
In the engineering school?
No, public policy.
So you never took, for example, fields and waves over in the EE department?
No, I didn't.
Okay. And so, but you're not aware that electromagnetic signals bounce?
Well, I'm generally aware of that, yeah.
Okay. Just like, if you shoot a basketball up at a basket and it comes down from the backboard, doesn't mean the person shooting the basketball was behind the backboard, right?
Right.
Okay. So when you say that someone's located at a particular location, that's just because of where the antenna is, right?
That's right.
Okay. You also testified earlier, and stop me if I'm wrong, that you attempted to interview Mr. Copeland, correct?
Well, I desired to. He had an attorney, and ultimately, it just didn't happen. Like, if I don't, there was no interest from that side in allowing for the interview.
You desired to interview Mr. Copeland.
Yes.
You reached out through his attorney, correct?
If I remember correctly. Well, yes, it definitely would have been through his attorney. And all I know is it just never happened. I can't recall exactly what the conversation was, but I do know it never happened.
Did his attorney say, yeah, Mr. Copeland would love to be interviewed. Let's make a date for that?
Sustained. He just said he didn't remember.
Okay. Let's jump to one more thing, then I'll be done. The gas station video from the Texaco, the one that's exterior to the gas station. How many times would you say you viewed that video?
Wow.
Roughly.
75 to 100 times.
And you saw someone that you believe to be my client, Diamante Kendrick, right?
Yes.
And you saw him in the Pontiac Bonneville, correct?
Yes.
And you saw the Pontiac Bonneville pull out of the gas station.
I did.
And Mr. Kendrick was in the Bonneville when it pulled out from the gas station, correct?
He was in the driver's seat.
Of the Bonneville.
Yes.
He was not in the Infinity, correct?
He was not.
Thank you.
Any other defense counsel have questions for this witness? No. Okay. Is there redirect?
Good afternoon again.
Good afternoon.
You were asked on cross-examination by Mr. Adams whether or not you saw communication between Demise McMullen and Kenneth Copeland.
Correct.
Paul?
Yes.
What was the number that you were able to obtain for Demise McMullen?
So the number for Demise McMullen was 470-217-6080.
And you were asked as well about efforts that you made to corroborate information that you were given during specific interviews. Do you recall?
I do.
I'm going to show you what has been marked as State's Exhibit 528 Yankee and ask if you recognize 528 Yankee.
I do.
How?
This is a picture that I obtained from Justin Cobb's Instagram page that I screenshotted.
Okay. Why did you, let me ask you first, is 528 Yankee a fair and accurate copy of the screenshot that you got from Justin Cobb's Instagram page?
Well, yes, though it's cut off a little bit on the right, where the timestamp is, the last number of the timestamp, it just says 201. Okay. But I mean, I recognize that it's otherwise fair and accurate. It's just cropped a little bit on the right-hand side.
Your Honor, the state tender states 528 Yankee as evidence.
I would actually object to it if it's not in the facts.
If it's what?
I would actually object to it if it is not as he remembers it to be, if it's been altered or if it's not the same that he's viewed previously.
Okay, well, it is admitted subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I'd also object to any hearsay that may be contained within that document.
I don't know if I don't know what the exhibit is. So is that an issue I need to take up?
I don't believe so, Judge. I mean, I can show. As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Okay. And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And I mean, that would, for the traditionally, that's what I would do with an Instagram page. It's just posted in public view.
Okay. And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment. And
Was it posted by the owner or user of the account?
That was false speculation, not object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to? What
I would
handle
renew
the
my
number
objection
is
and also
next
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay,
and Your Honor,
when we were up here at the bench.
so, Your Honor, I'll ask additional questions that I think will.
Sustained.
Okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, so
Your
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
may I respond?
You may.
Judge,
Can somebody put the document up? I don't see.
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire cross
number was the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous, because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, it's all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing the court, and I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promoting statement is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
Thank you. Ladies and gentlemen, upon further discussion, that last exhibit, which is State's Exhibit 528Y, is excluded from evidence. And so that means that y'all need to disregard it entirely in your thoughts and in your deliberation in this case. And as well, you need to disregard any testimony that might have been given about that particular exhibit.
DDA Sprinkle, you were asked on cross-examination about whether you attempted to determine whether Kenneth Copeland, in the words of Mr. Adams, lied when talking to the police. Do you recall that question?
Yes, generally, he asked me something about whether I endeavored to detect that or figure it out.
Did you make any steps to determine or to corroborate the information you gained from Kenneth Copeland?
I did.
Would you tell the jury what steps you took to corroborate information that you gained from Kenneth Copeland?
Well, there was a number of things that I did. I, in particular, looked at all the cell phone records. Like, for example, so I looked at the call detail records, the times that people were called or made calls, the parties to those calls, and also the towers that the handsets utilized by those calls. And as I've testified previously, you can tell somebody's general location based on the tower and the sector of the tower, the antenna of the tower that their handset utilizes to facilitate the call. And also you can, in knowing who somebody is communicating with at a given time, that can tell you a little something as well. And so when I compared Mr. Copeland's statements to my analysis of the cell phone records, I tried to the best of my ability to corroborate as much of his statement as I could by analyzing all of that.
You were also asked on cross-examination, DDA Sprinkle, did you utilize statements from other witnesses to corroborate information you obtained from Kenneth Copeland's interview?
I did.
Citation clause.
Not just from that. So overruled.
You were asked on cross-examination whether you obtained a wiretap for Defendant Williams' phone. Do you remember that?
Yes.
All right. As it relates to the Donovan Thomas murder, would it be something you would expect to be able to get a wiretap for a year and a half later?
I'm going to object on the grounds of speculation.
Overruled.
As it relates to the Donovan Thomas murder.
So wiretaps are for evidence of things that are going to be talked about in the future. I'm trying to think. I don't believe I've ever obtained a wiretap to investigate a crime that happened in the past, solely to investigate a crime that happened in the past. That's not to say you couldn't. I have heard of such things, but I've not personally done it, and I did not do it in this case.
You were also asked on cross-examination about the photographs that depicted, or the social media postings that depicted defendant Stillwell. Do you recall that?
Yes.
And did you testify that you obtained information about the photograph from a person you spoke to?
Yes. Yes. Apart from what was just, available in the public internet form, that being the website from which I obtained them. Yes, I did. I spoke with someone about the photograph.
Okay. Mr. Adams asked you about Detective Thorpe consulting with Detective Gaither and Detective Dennis. Do you recall that?
I do.
Do you have any knowledge of whether Detective Gaither or Detective Dennis were consulted with before warrants were taken out by Detective Thorpe? In other words, did he seek their permission to take out the warrants?
No.
Do you have
No.
any knowledge about that?
No, I don't believe he did. No.
Okay. You were also asked on cross-examination by Mr. Adams about the dismissals and the NPGJ for certain people that warrants were initially taken out for the murder of Donovan Thomas. Do you remember that?
I do.
Were the dismissals of those warrants in any way based on the additional investigation that you did with your investigator, David White, into the murder of Donovan Thomas?
Well, no, not the one with Sledge. That was Mr. Antonio Sledge. That was the preliminary hearing judge that threw that one out.
Mm-hmm.
So,
Did you?
Hang on. All right, I don't know if your mic's on at all, but
I'm sorry. It was non-responsive, and it was testimony about other court proceedings, which I believe is inappropriate and hearsay.
overruled.
Did your investigation into the murder of Donovan Thomas lead you to present MPGJs for people who had been arrested for his murder?
well, yes, for the people for which we didn't, the people that we didn't prosecute for the murder, yes.
Mr. Adams asked you specifically about corroborating the information you gained from Kenneth Copeland's interview. And specifically, he asked you about phone calls with Demekian Garlington. Do you remember that?
Yes.
Are you able to tell the jury what information Kenneth Copeland provided you that you were able to corroborate?
Well,
Okay, I think your mic's still out, but sustained.
You were asked on cross-examination by Mr. Shart whether Kenneth Copeland said he was at the Green store at the time of the murder. Do you recall that?
I do.
When you are looking at cellular location information for cell phones, do you look at a static point in time to determine what a person's handset is doing? In other words, do you only look at the time of the incident in question, or is the time leading up to it and the time after it also relevant?
Well, yes, the times before, during, and after the homicide, it can absolutely be relevant.
Was there any point during your investigation where Kenneth Copeland said, I was at the green store at the time of Donovan Thomas's murder?
I don't remember that. I don't have every single thing that he said during his, particularly the 9-hour statement, committed to memory, but I don't recall him saying that, being even cognizant as to saying that he knew exactly where he was at the time that Donovan Thomas suffered his fatal gunshot wound.
As it relates to what Kenneth Copeland did tell you about his whereabouts on the day of Donovan Thomas's murder, were you able to get information as it relates to any significant others in Kenneth Copeland's life about where he was on the day of the murder?
So to be clear, I never spoke with Kenneth Copeland, but from the statements that he provided, yes, I believe so. I definitely, because he would reference people that he knew, I sought to identify, for example, phone numbers for those people, because again, that would go to my corroborating his statement based on, among other things, his phone logs.
Okay. When you testified on cross-examination that you were looking at big things for inconsistencies, what did you mean by that?
Well, so, a big inconsistency would be, as I cited, if somebody were to say, for example, I witnessed a murder and there's a video of the vantage point that the person cited that they stood, and then I look at the video and there's nobody there, that would be a big inconsistency that I would seek to clear up. And indeed, I did that here. That's what I meant by that. Something that's glaring, something that you're not able to, something for which there's not a reasonable explanation that can clear this up for you.
You were also asked on cross-examination about who was in possession of the Infiniti that was at the Texaco prior to the Donovan Thomas murder. Do you remember that?
Yes.
Why did you say, do you mean, or if you mean actual possession? Do you recall responding
Yes.
regarding actual possession? Why did you say that?
Well, the person that was actually like at the helm of the vehicle and had actual control of the vehicle, not the person that had some sort of legal right to the vehicle through a lease agreement or otherwise.
Did you see anyone else's name on the rental records for the vehicle, the Infiniti that was at the gas station up the street from where Donovan Thomas was gunned down?
I don't know. I don't think so. Just Mr. Williams.
Mr. Adams also asked you about phone calls between Demise McMullen, Kenneth Copeland, and Demekion Garlington. In your review of Kenneth Copeland's interviews, do you recall him ever giving a specific time that he was in the car, as in 1 a.m., 4 a.m., a specific time that he was in the car with Demise McMullen and Demekion Garlington?
Well, it was afterward. But no, I don't recall the specific time, or if he cited a specific time. From what I remember, he would cite generally he'd say, oh, I think it was around 10:30 or something. That's not a quote at all, what I just said. But no, I don't recall him having like a regimented timeline, you know, like at 1927 hours, we went to this location or anything like that.
Okay. You were also asked about the absence of phone calls in the phone records that you obtained as it related to Defendant Williams and Demekion Garlington. Do you remember that?
I do.
Are you able to tell the jury whether the phone records or the call detail records that you obtained would reflect FaceTime calls?
No.
Would those call detail records reflect WhatsApp calls?
No.
Do you know, or can you even say that there was no communication between Defendant Williams and Demekion Garlington?
No, I can't say that. The records, like I said, the call detail records are only those that were logged by the cellular phone company. A FaceTime call would be facilitated through Apple, the Apple Corporation's platform infrastructure, rather.
Did you ever charge Defendant Williams with Donovan Thomas's murder?
No.
You were asked about the headliner in the Infinity, or obtaining gunshot residue from the Infinity that you found a year and a half later in a different state. Do you recall that?
Yes.
Did you have any information about the number of people who had been in the Infinity between the time that Donovan Thomas was gunned down and the time it was located in a different state?
No. And from what I recall, Hertz wouldn't have been able to provide me with records of that anyway. It's very interesting. I couldn't ask for the rental history on a specific vehicle. I could only ask for the rental history of a specific person.
And did you have any information about the number of times the interior of that vehicle had been cleaned, laundered, or anything else in that year and change?
No. Not that I recall. No.
Without that information, why then did you seek to obtain a search warrant?
Well, I primarily wanted to obtain the data from the vehicles, the Infinity's infotainment system, you know, the system that you might hook your phone up to. I thought that if we were able to get a search warrant, we might as well also analyze the interior for gunshot residue. I mean, I was aware of what the probative value of that may or may not be, but I thought better to have it and not need it than the other way around. So that was the rationale there as to why I did that, or was contemplating that. That ultimately never happened.
Mr. Adams also asked you about not getting cell site data for the phone number that you determined belonged to Demekion Garlington, or at least that you testified on cross was Demekion Garlington's phone number.
Well, I don't know that I definitively figured out that that was Demekion Garlington's number. No.
And what information could you get without having probable cause to obtain cell site location data?
You can obtain the subscriber information. That is the information that the phone company has on file for the person that pays for the line, if they have that information on file. Mm-hmm. You know, the person that they would bill on a monthly basis, basically. And also the what are called call detail records. These are just I mean, these are anybody who's had phone service, you know, and they've seen a bill and it has a list of your phone calls. Well, that's essentially what this is. It looks a little bit different when you get them pursuant to a legal process like this, but it's just a list of the incoming and outgoing calls and text messages, not iMessages, incidentally, not messages sent between iPhones, but text messages, SMS messages. And that's essentially it. Notably absent from records, call detail records, if you don't have a search warrant, in other words, there wasn't a finding of probable cause, is that tower location data that I've testified to. That is the general area where the handset was, the equipment to which the handset connected to facilitate the communication. Without a search warrant, you cannot get that. You can only get the dates and times of the calls and the numbers that were that were part of that call.
And talking about the lack of calls in those records between Defendant Williams and Demekion Garlington, if two persons or two handsets are next to one another, do you generally expect to find phone calls between those two people if they're sitting, for instance, in the same vehicle?
Well, it's not impossible to call somebody sitting in the same vehicle as you. So I don't know why somebody would call somebody that's sitting down. Maybe they can't find their phone. I call my phone, I can't find it. I mean, there could be any number of reasons. I can't speculate as to why you'd call somebody in your immediate spatial proximity.
Who was it that gave you the information about the photograph where Shannon Stillwell is depicted?
Quindarius Zachary.
And who was it that gave you the date, or the approximate time or date that the photograph was taken?
Quindarius Zachary.
And finally, you were asked about the length of time people remained in jail after being arrested for Donovan Thomas's murder. Do you recall that?
No, I don't recall specifically being asked about the length of time they spent in jail, but I recall being asked about their something along those lines, similar to that, maybe.
Okay. If a person is held on something other than the warrant for murder, would an MPGJ or a dismissal of the murder charges automatically allow them to be released?
No.
Mr. Sprinkle, picking up where the prosecutor left off in regards to that NPGJ, what we do know, though, is that Mr. Copeland's NPGJ, the charges or the document that dismissed the murder charge that first put him in jail in 2015, that NPGJ wasn't done until 2017. Is that correct?
That sounds right. I didn't file that, but and I don't recall who the prosecutor was that did, but I was aware of it. But I don't know that he was ever actually booked into the Fulton County Jail on the murder charge, though.
You don't know that?
I think he was in the federal jail, if I remember correctly.
The other three were, though, right?
Well, not Mr. Sledge, Mr. Garlington, because like I said, Mr. Sledge's case was dismissed in January 2016. Mr. Garlington, Mr. Jackson, aka Mr. Stillwell, yes.
Well, let me ask you this. You said Mr. Sledge's charges were dismissed in 2016. Where was he before his charges were dismissed?
Fulton County Jail.
Right, so in jail on that murder warrant, right?
Correct.
Okay, so he was in fact imprisoned on Thorpe's murder warrant until until his charges were dismissed, right?
Well, in the jail, not prison, but yes, he was incarcerated. Yes.
Okay, I mean jail, prison. You're not on the streets. Your freedom's taken from you, right?
Right. I mean, it's a distinction without a difference. I'm just saying that prison and jail are two different. Yes, his freedom was restricted. He was not allowed to leave. He was in a government facility.
You were asked a number of questions about cell phones, and I wanted to kind of pick up there. Now, you were aware from the work that you had done on the case, as well as listening to Mr. Copeland's statements, his interviews, that he had multiple cell phones in January of 2015. You're aware of that, right?
Mr. Copeland did?
Mr. Copeland, yes.
I'm sorry, I don't I have one number for him. I don't recall him saying that he personally had multiple cell phones. I don't remember that now.
How about this? Do you remember in an interview that he had with the detectives where on January the 11th of 2015 at about 3:30 in the morning, where he talks to the detectives about his cell phone or cell phones? Do you remember that?
No, I don't recall that. I know I'm familiar with that interview, but I just don't remember him talking about multiple cell phones or anything like that.
Okay. Are you aware that there are no calls? And if we're just going to just talk about the number that you're familiar with in regards to Mr. Copeland, let's focus on that one.
Okay.
Right? Are you aware that there are no calls from Mr. Copeland's per his cell phone records on January 10th, 2015 between 6:58 p.m. and 7:26 p.m.? Are you aware of that?
I don't have the full records in front of me. I do see that the records that I examined, the last relevant call is at 6:58 p.m.
Okay. And you had, when you got his phone records, we've talked before about the fact that you've got the cell tower data. So you had some idea of where you thought he was at particular times based on those records, right?
I take that back, actually. At 7:01, 7:23, 7:24, 7:26, 7:28, 7:43, 7:45, 7:49, 7:51, and 7:54, there were calls.
Calls coming in or going out?
Let's see. There was an inbound call at 7:01. There was another inbound call at 7:23. There was an outbound call at 7:24. There was an inbound call at 7:26. An inbound call at 7:28. An outbound call at 7:43. An outbound call at 7:45. An inbound call at 7:49. An inbound call at 7:51. And that's it.
Okay. And so having his records, knowing the cell tower data, you were able to opine on where he was at a particular time on that night, January 10th, 2015, right?
Well, his general the part of town basically that his handset was located.
You placed him, according to your report, either at or near the McDonald's on the evening of January 10, 2015. You remember that?
I do.
All right. Now, you don't have any cell phone or cell tower data records on Mr. Copeland that shows his phone going to what we've called the Sky House on that night, do you?
I don't recall that. Yeah, I don't believe so.
Nothing in your records that refreshes your recollection that you've got any of that. You don't have any of that to show that he went to the Sky House or his phone, the phone that you're saying is his, went to the Sky House on that night. True?
That is correct. I don't believe that. Yeah, just taking a look at my notes, it doesn't appear to me that I found that his phone traveled to the Sky House.
And one of the things that you were asked about these phone records, I think the prosecutor asked you, well, the phone records won't show you WhatsApp communications, right?
That's correct.
Asked whether or not the phone records would show you, or said that they would not show you FaceTime communications, right?
Correct.
And so I think your answer, tell me if this is what you said, was that you can't say that there was not any communication between Mr. Williams's phone and, for example, Mr. Copeland's phone on that night. You can't say that because it could have been maybe WhatsApp or FaceTime, right?
Yeah, some sort of platform for which we just don't have logs.
Right. And so what we have ultimately is that there is no evidence, none, right? Because we can't assume a negative. Mm-hmm. There is no evidence that there was any communication between those phones on that night, right?
Correct.
Prosecutor asked you, said, you never charged Mr. Williams with Donovan Thomas's murder, right?
That's right.
You did not.
That's correct.
Because you had no evidence that he committed that murder, true?
Well, yes, but I also can't charge people with crimes. I'm not a police officer and I'm not a grand jury. But I think I understood what the question was intended to elicit. And yes, that's correct. I didn't think that there was evidence to charge him.
I got a question about a video. I'm not sure if it was a prosecutor that asked you or whether maybe it was Mr. Short who asked you about a video, specifically at the McDonald's. You didn't get any video from the McDonald's, right?
I did not.
Okay. Are you familiar with different recording systems where there's something recorded and it's kept for a certain period of time and then either recorded over or deleted? You familiar with that?
Yes.
Okay. I think we talked about that a little, or you talked about that a little while ago, right?
Yeah, it's basically that there's only a finite amount of recording space, so eventually the recording has to start over again.
Now, when we're talking about that, the recording starting over, you said before that some recording systems record for a certain period of time and then maybe a day, maybe a week, maybe 2 weeks, something like that. You remember that testimony?
Yeah, depending on the size of the recording, the size in megabytes of the recording media. I mean, presumably they don't have them on tape anymore. Yeah, it would depend on that.
Right. So if you've got, not hypothetically, but just based on your knowledge and your experience, right? Mm-hmm. A system that records every 2 weeks. It's not that you've got 2 weeks of recordings, then all of a sudden that goes away and it starts over, right? Isn't it just that you have one day and then a particular day is taken up by the following day as it starts and goes all the way through? You understand what I'm asking you?
Yeah, I think I understand. It's a hard drive that the data is being written to. So, I mean, I don't know that as the drive fills up, you're right. I guess what you're asking is that after 2 weeks, does all the data just immediately go away at the 2 week mark? No, I wouldn't think so. No, I would think it would be an incremental deletion.
As it relates to this, if there's not knowledge, I would object based on speculation as to any particular.
Sustained.
Okay. All right. Mr. Sprinkle, you were asked, I think following up on a question I'd asked you, then the state asked whether or not you were aware of if Detective Thorpe consulted with Detective Dennis or Gaither. Remember that question?
Yes.
And we had talked earlier when I questioned you originally on Cross about the fact that you knew that there were interviews, for example, with Mr. Copeland, where all of those detectives were present, right?
Yes.
And those would have been things that took place after January 10th of 2015, correct?
Yes.
As the murder investigation was being conducted, right?
Correct.
Okay. Then we have the arrest of these 4 individuals on October 20th of 2015, right?
Correct.
Okay.
Well, I don't know that they were all arrested on that day, but that was the date the warrants were obtained.
Got you. That's the date that Detective Thorpe made a decision, and I'm gonna arrest these 4 guys or get a warrant for their arrest, right?
That's right.
Okay. Which he was wrong about, right?
Well,
Yeah.
Sustained.
Okay. You were asked whether or not you thought that, or you knew whether Detective Thorpe sought permission from either Detective Dennis and or Gaither to swear out the warrants for the arrest of the individuals in the Donovan Thomas case.
yes.
All right. I think your response was either you don't know or you don't think he did.
Well, no, I don't think he did. That'd be very odd. The permission lays with the magistrate judge or a judge, not with his coworkers at the Atlanta Police Department. But to my knowledge, no, that never happened.
But what you do know from speaking to the detectives, and by the time you grab a hold of the case, right, is that certainly Detective Gaither and Detective Dennis had been involved to some extent in the murder investigation, right, or at least assisted with it, right?
Yes.
And after Thorpe swore out the warrants in October, they were aware that these 4 people were sitting in jail, right?
They were.
Neither of them, these 2 seasoned investigators, either came to Thorpe or you and said, hey, you know what? We got some problems here. I think we got Detective Thorpe didn't do what he was supposed to do. We need to take another look. That never happened, did it?
Objection, relevance, and vague and compound.
Sustained.
In regards to the infinity, we talked initially, I questioned you, not talked, about possession of the infinity. And you used the word actual possession.
Right.
Right? You said, no, I do not know who was in actual possession of the infinity on January 8th, 9th, 10th.
Right.
Fair? Okay. And you were just asked a question about the importance of actual possession. And actual possession is something that's important to you or was important to you in making a determination about the infinity, right?
Yeah, that's right.
Right. Mr. Williams's name appears as the person who the car was rented to, right?
Yes.
Right. Now, in terms of your investigation, if you believed that there was something that was done or crime committed using the infinity, right, that is why it would be important to determine who was in actual possession of the infinity at the time that the crime was committed, right?
That's correct.
Because I can rent a car and it be in my name, but if someone else has possession of the car and is committing the crime, they're the person that's committing that crime, right?
That's correct. I mean, unless I were able to show that somehow the people that actually possessed the car did so with the encouragement of the lessee. But yes, you're right.
And specifically in regards to this case, this infinity, Mr. Williams, you had no such evidence. True?
That's correct.
Your investigation, I use the term investigation, your work on the case led you to recognize that there were inconsistencies and you couldn't trust what Kenneth Copeland was saying or what he had said in his statements. True?
Well, no, I thought that his statement, there were a number of things that I thought were accurate about his statement.
And some things were inaccurate, right? As far as you knew.
You would have to, his statement was there was a lot in his statement. I tried to look at his statement generally based on what he was able to remember when he provided that 9-hour statement and primarily compare it with the phone records. And when I did that, I didn't see any glaring, I can't recall seeing anything that was just wholly inconsistent or impossible. Like, for example, the first witness, Spencer Wright, what he said happened was impossible. He wasn't there. I didn't see anything like that with Kenneth Copeland.
Did your investigation on this case, by the time you picked it up or got involved in it late 2015, 2016, seeing everything that had been done or not done thus far, also lead you to believe that you couldn't necessarily trust the investigative work of Thorpe, Gaither, and Dennis?
Well, no. Well, I mean, yes, there was a mistake. Detective Thorpe made a mistake in not taking a look at the video and checking to see if the witness was actually where he said he was. Okay, but would that mean that I wouldn't be able to trust anything in the entire investigation? No, I wouldn't make that sort of blanket condemnation such that I would just disregard everything in the entire file and every finding of fact made by the police. No. I mean, I can see that a mistake was made in one part of the investigation, but there are other parts of the investigation that were not as erroneous.
His mistake put people in jail, though, didn't it?
Yes.
That's all.
All right, any other defense attorney have redirect? I mean, I'm sorry, not redirect, recross? No, you're all right. Okay. Okay. All right, Mr. Sprinkle, thank you for your time. I think it sounds like we might see you again at another stage in this case, but you are free to go for now.
Thank you, Your Honor.
And thank you. So, Your Honor, I'm objecting to a wholesale playing except for what the court redacted from Mr. Zachary's August 5, 2015 video audio recording interrogation. And there's Georgia cases that I have at my fingertips as well. But the first one is L as in laughter, K as in kitten, L as in laughter versus Ellington, ELLINGTON. Your Honor, it's 2018 United States District Court, Lexus numbers 208774, decided December 10th, 2018. And in that case, the district court wrote that the trial court ruled that because AL's statement during the it's CAC, but Child Advocacy Center interview were hearsay, and the prosecution had not introduced the interview, counsel could only introduce those portions of the interview where AL made an inconsistent statement, not the entire interview. And that's what I'm saying. Here, the state, and I raised this at your bench 3 times. I said what I foresee is that the state is not introducing the interrogation, either one, there were 2. They're going to not use Mr. Zachary, and they're going to put it up with another witness, and you said, we'll see what happens. We'll see what happens in the future. Well, that's exactly how it played out, and it is my opinion that if there are true then I understand that. And it comes in under 24.8.801 D1A, because it would not be hearsay, because it would relate back to OCGA 24-6-613, prior inconsistent statement. But the state does not have a Kenneth Copeland where he would just say, yeah, I don't remember if I said it, but I lied. They have Mr. Zachary saying, I said that. I am a liar, but I said that. And that's different than the just, I'm a liar, I don't remember, I don't recall. So unless the state can go piece by piece on what is an inconsistent statement, I'm objecting to just having a trial by prior recordings. The state then puts it on the accused and said that, well, we objected to it taking so long, to the state going through the entire interview. The state was asking about, how old are you? Do you have a brother? Where do you live? I mean, all this just page by page, but they did not hit the specific statements that are now deemed inconsistent statements. And I'm objecting to the wholesale playing of a recording and the witness is gone. That's my objection. I have a Georgia case too, and that is Gibbs, GIBBS versus State 340, Georgia Appeal 723. It's in Division 2A, as in Elisa, 2017 case.
All right, thank you. Ms. Love.
Your Honor, I believe that the court accurately surmised that the testimony of Quindarius Zachary was given the way that he testified and what he testified to, much like with other witnesses in this case, he has set up where he has denied with the state information that he gave in the interview. He has claimed to not recall information that he gave in the interview. He has claimed to have lied about specific information that he gave in the interview, even to the extent that when asked identical questions by opposing counsel, he would give a completely inconsistent answer to opposing counsel. For instance, do you know this person? To me, he would say, I can't recall. 5 minutes later, to Mr. Steele, he might say, yes. Or to me, he would say, I can't read. 5 minutes later, he's reading a book placed in his hand. So, Your Honor, I think that the court had it right. I would ask that the court allow us to present to the jury this pertinent information and relevant evidence.
All right. Yes.
I just respond. The part I disagree with is the state has already presented this evidence. When he's asked, did you say Shannon confessed? And he says, yes, I did tell the police that, but that was a lie. They've gotten that information out. He has confirmed that he told the police that back in 2015. And that's the whole point of using extrinsic evidence, as I understand it. The whole point of using extrinsic statements or prior statements to prove the point, it's when the person's denying it and you have to bring in that statement. I'm sure I'm sure if we look at the transcript, there are going to be a few times, especially towards the end of, I believe, the second day where Mr. Zachary was frustrated and got into I don't recall mode. But other than that, he acknowledged what he allegedly said and said it was a lie, and this is why I lied. And I don't believe that lays the foundation for what the state wants to do.
Okay, so I think that by and large, he said a whole lot of I don't remembers and a fair bit of, if I said that, I don't remember saying it, but if I did, I lied. To the extent that the statement itself can come in as substantive evidence as a prior inconsistent statement. And if the defense has particular parts of the statement that you believe that actually were sufficiently handled such that the extrinsic evidence of that shouldn't come in, then please let me know. But I think by and large, it can come in, subject to the redactions, of course.
Can I respond to your request? He certainly acknowledged making statements about Mr. Stillwell allegedly confessing in both statements. And the reason I can remember that is because I went through them and talked about how they differed. But that was standard impeachment comparing two statements, but at no point did he deny making those statements. So I think that's pretty clear that he did not deny those. He also did not deny giving when I believe it was Miss Love leading, or I shouldn't say that. Miss Love was asking questions and getting into alleged facts that Demekion Garlington allegedly said. I believe that Mr. Zachary acknowledged telling the police about that as well, except he just said that, Garlington was a play. Garlington had given him the play was his ultimate explanation, but I don't believe he denied that either. So I think, sure, there's a lot of tangential points that perhaps a foundation was laid, but on the main points as it relates to Mr. Stillwell, at least, I don't believe that he denied making those statements, and therefore I don't believe it's appropriate to play the prior inconsistent statements because they are not inconsistent.
By the same token, Your Honor, he also did not deny having said in his previous interview that Mr. Kendrick had admitted to being involved in that murder. He said that it was a lie, but he did admit to having said that.
All right, I'll consider those over the break.
Your Honor.
One more, Your Honor.
Yes.
He admitted that Jeffrey Williams, that he said, Jeffrey Williams gave the infinity vehicle to Shannon, allowed Shannon Nard to up and drive as well as Mr. Copeland. And he was never even asked about giving Jeffrey Williams a gun, so it can't be inconsistent. He was asked about that. Those two items I object to.
Asking about giving Jeffrey Williams a gun.
Yeah.
Give me a little bit.
And it's in his statement to the law enforcement.
About Zachary giving Jeffrey Williams a gun?
Yes. But he never was confronted about that.
Okay.
Your Honor, now that I think about it, he also acknowledged giving the statement to law enforcement about yes, he acknowledged giving the statement to law enforcement about Mr. Copeland being at Big Boo's house and then saying, let's go, and then returning and learning that there was a price paid. on the head. He acknowledged saying all that. He said he made it up, but he acknowledged saying all that. And he also acknowledged telling the police about what he observed at the Lil Wayne bus shooting when he was at Club Compound and cars leaving from there. So all those things were touched upon on his direct and acknowledged by the witness.
Your Honor,
Yes, ma'am.
saying that he told the police that and then saying, but it was a lie, makes the prior statement an inconsistent statement. Additionally, he said to the state, I was high on, or I was withdrawing from 3 or 4 different drugs, depending on what time he was talking about it. So his intent was to suggest to the jury any way he could that anything he said about any, and I specifically asked because anything he said about either of the 3 defendants in this case that he talked about, he denied were true. Everything.
Okay.
You were not able to determine who it was that actually rented the vehicle, just that it was in the name of Jeffrey Williams. Isn't that right?
It was in the name of Jeffrey Williams, his driver's license number, and a signature. There's a signature as well.
Now, tell me the date that that vehicle was rented.
From what I remember, January 7th, 2015.
All right. So that would have been 3 days before January 10th of 2015, correct?
That's right.
All right. Now, tell me, if you can, who had possession of that vehicle on January the 8th of 2010?
2015?
2010? 2015, yes.
Yes. I don't know.
You don't know who had possession of that vehicle on January the 9th of 2015?
I do not know.
And you certainly don't know who had possession of the vehicle, no personal knowledge of who had possession of that vehicle on January the 10th, 2015.
If we're talking about actual possession, the
Actual
person,
possession.
then no, I do not know.
Okay. You never strike that. By the time you came into this case, that rental vehicle, I mean, it had been at this point, what, a year since the incident? We're talking January 2016 is when you're in this case?
Yes, I obtained the records from Hertz in 2016. It would have been over a year. It would have been around April of 2016 when I obtained the records from Hertz.
Okay. Now, I want to ask you about some of the things you did not do. Okay.
Okay.
You referenced earlier there were a lot of numbers being phone numbers being kind of, I don't want to say thrown at you, but put in front of you in terms of you were able to get information on this phone number and that phone number, the frequency of communication. Is that, you remember those questions?
I do.
And you did in fact have the ability to procure phone records by way of either subpoena or search warrant or court order.
That's correct.
Okay. You were able to get a lot of different phone numbers on people that you thought or individuals you thought might have been of some interest in the case. Is that fair?
That's fair.
Okay. You also, when you request those phone records, you have the ability to request cell site or cell tower information, correct?
That's correct.
Now, and I know you're not an expert, but you are familiar with utilizing, maybe with an expert, cell site and cell tower information to try and make a determination as to where someone might have, or where a phone might have been at a particular time. True?
Yeah, I'm pretty familiar with plotting cell phone records. I'm not like an FBI CAS team member or anything like that, but I can hold my own.
Right. So having listened to Kenneth Copeland's statements, and you did that, all right? Mm-hmm. Having listened to his statements, one of the things that you would have wanted to do, I presume, I'm asking, is try and determine whether or not you could corroborate certain information in his statement. Is that about right?
That's about right.
All right. he gave, like we said, at least one 9-hour statement, and he gave a lot of statements. There was a lot to listen to from Kenneth Copeland.
Yes.
And he gave information that you would have used to follow up in your investigation.
That's correct.
Right. The name Demekian Garlington came up in your investigation. Is that right?
Yes.
Right. There was this reference in listening to Kenneth Copeland's statements. There was this reference to a conversation, phone calls that he would have had with Garlington, right?
That's correct.
And it would have been some interest to you to figure out whether or not what Kenneth Copeland was saying, not just about that, but everything was corroboratable, was true.
Yes.
Right? Or whether Kenneth Copeland was lying to y'all, lying to the detectives, not y'all, because he had already been interviewed, right?
Right. That's right.
Because you considered him to be a pivotal witness in the case.
Yes.
Right. And some of the things that he said, you would have considered to be pivotal things that you wanted to follow up on, right?
Yes.
And if you have a witness, just like Spencer Wright, for example, if you have a witness who you think has pivotal information, but that witness is proven to be a liar, that's something that you want to know in regards to the investigation. True?
That's true.
And one of the things you could have done in regards to Kenneth Copeland and any statements he said, phone calls he said he may have had with someone named Demekian Garlington, is you could have gotten Garlington's phone records to determine whether or not those communications took place, right?
That is correct.
And also where Mr. Garlington was to see whether that comports with what Kenneth Copeland said, right?
That is correct.
Now, you got Kenneth Copeland's information, his phone information, right?
I did.
You got his location, so you knew, or at least the phone, where that phone was at certain times on the night of January 10th, 2015, right?
Well, to be specific, what you see with tower data is the tower and the side of the tower that the phone utilized. That can be a pretty large area. In a city with a lot of cell phone towers everywhere, you get a little bit of a better idea, but I just want to make sure that we're clear that it's not the exact location of the phone.
Sure. Not the exact, you can't pinpoint within feet or maybe not even within a block, but it was important enough to you to get that information on Kenneth Copeland on the phone that you thought was being used by Kenneth Copeland, right?
Yes.
Now, you did reach out to get information on Garlington's phone, or what you thought was Garlington's phone, right?
There was a number that I thought may have been Garlington's number.
Sure.
And I believe I referenced that in my report. And correct me if I'm wrong, I believe it was maybe a Sprint number, or maybe I can't remember exactly. It wasn't in his name. I was never the short answer to your question is I was never able to get tower data for Demekian Garlington.
Well, it's not that you weren't able to get tower data. You requested the data for that phone number and specifically requested it without the tower usage logs. Isn't that right?
Yes. So there was a number that was in Kenneth Copeland's records, came back, I want to say, to a female. Now, and I remember, and this is, I'm thinking, and unless there's something that can refresh my recollection, from what I remember, I couldn't prove. It's one thing to get call logs are very easy to get. You don't need probable cause for those. But to get location data, you need probable cause. And I remember, from what I recall, I didn't think that I had probable cause to get tower location data for this number. Usually I'll try to do something like, there's a number of things. Like if I find a jail call to the number and I hear the voice that picks up, I say, oh, well, that corroborates that number is in fact that person's number. Or if somebody cites it on their Instagram page and says, call me on this number, that's going to get me to probable cause that that's that number. But if it's just that it's in temporal proximity. And I think there was another issue with the retention period of the number. I don't, all I know is I didn't think I had probable cause. I never got probable cause to get the tower records.
Let's work backwards a little bit, right? Let's start with this. When you sent out the request for the records that you thought was a number to Demekian Garlington.
Yes.
You requested those records specifically without tower usage logs, right?
I did.
Okay. Now, you had previously requested records for what you thought was Kenneth Copeland's phone number with the tower usage logs, right?
I don't know that it was me that did that. It may have been investigator or Detective Dennis that did that.
Right. But one thing that you knew, I mean, you honed in on the fact that there was supposedly this call between Kenneth Copeland and Demikian Garlington, and they were supposed to be at a specific place on the night of January 10th, 2015. Isn't that right?
That's correct.
Right. And so you had listened to Kenneth Copeland's statements, and you knew from Copeland's statements that he made reference to Wade Garlington, who was an important witness to you, right?
It was.
Right. You knew that Copeland